All right, it is Friday, November 21, 2025. Welcome to the Borderlines Podcast, a Canadian immigration podcast. Today is Deanna and I. First, before we get into today's topic, which is express entry refusals and kind of refusals in general, I do want to do a bit of, I guess, like a housekeeping. First, as I always forget, please like and subscribe. If wherever you listen to this podcast, or if you're on YouTube, I guess subscribe. It's also the easiest way to leave comments if you're watching live. But last week, during our episode on the immigration levels plan, I mentioned that as we were recording the episode, some people on Instagram were commenting about the OINP Skilled Trades draw, or something to do with the OINP Skilled Trades stream. At the time, I assumed it was a draw and congratulated people in that program. As it turns out, it was not a skilled trades draw. It was Ontario canceling all applications that were in the system, which is obviously not good news for those who were in the program. So the complete opposite of what I thought as the comments were coming in. For those who aren't aware, Ontario passed legislation giving the province the ability to cancel applications in the OINP for pretty much any reason, everything from housing to fraud. And in this case, what they've said is that there is a sufficient level of fraud within that program that it was no longer possible or worth it, I guess, for the OINP to individually assess applications as to whether there was fraud or not. So they were just canceling everyone. Which is awful for those in the system. Whether that is a preview of what may come under Bill C-12 federally, we will see. Whether other provinces adapt similar legislation that Ontario has. Right now, I think Ontario is unique. We will also see. But yes, that was the big development last week. I don't know, before we get to our topic, you spoke at Bill C-12 or on Bill C-12. Deanna, do you have any hint as to whether fraud might be a reason why they will be canceling applications federally as well?
Yeah, 100%. I mean, the minister was pretty, C-12, there was 2 days of hearings. Actually, I think that there's been a third now, and I didn't actually keep up. I decided to actually get back to the practice of law this week because it was pretty all engrossing the week that I was in Ottawa. But the 2 days that I was very involved in, the minister testified about what the intent of the bill was, and was pummeled with questions from both sides of the House, and said really the intent with the bill was to use the cancellation provisions to, in limited set of circumstances, really, and the examples she provided were in the case of war, pandemic, and mass fraud. And so that was something that I was appearing on behalf of the Canadian Bar Association with Gerald Robinson, and that was something that we spoke to directly, because we believe that really mass fraud is pretty much the key target. And there have been stories already coming through the CBC talking about like leaked memos about how really mass fraud is the key component of that. Talk about, there's a lot of fraud coming out of Bangladesh and India in particular, and that this tool would be used to cancel applications that are pending there because there are higher numbers of fraudulent applications. And so we talked about this in particular in our written and in our oral submission, saying like, how can you do this in a way that's not discriminatory? Because you can't just cancel an entire country's applications on the basis that some of them are fraudulent and then not call that discrimination based on country of origin. So it's very hard to define. And after the hearing, we were approached by members of parliament saying, how would you suggest? And the other problem with it, of course, is that the bill itself doesn't say that this is the basis upon which this cancellation authority can be used. It just says we have this cancellation authority and we can use it anytime cancellations are in the public interest. So that's the only confining factors. And so it's extremely, extremely broad. And it's also that the changes can be made by order in council. And so it doesn't even have to go through debate and public being posted on in the Canada Gazette and going through all of this normal regulatory review. So that's exactly what our concern was and put forward. But it was pretty clear to me from conversation after the fact that there was no real intent to make deep changes to the bill, that both parties seemed like the Liberals and the Conservatives were both pretty much aligned that this bill was going to go through. And they were maybe looking at ways of tweaking it a little bit. Are there ways of carving out certain groups, particularly with the refugee provisions, of making some small adjustments. But I didn't get the sense that they were looking to like completely reframe it.
Michelle Rempel on Twitter, the conservative opposition critic, has said that she's going to have a ton of amendments, mainly around criminality in the immigration system, as well as asylum claims. She had a presser on Twitter, I think, probably also in the news, but I saw it on Twitter, X. So we will see. The actual wording hasn't been released. There's an open invite for her to come on the show because I think she is, regardless of whether you agree or not, she's definitely actively engaged in her portfolio as opposition critic and is proposing a lot of ideas. It's funny, as you said that, that you and Cheryl at the committee were like, you can't do that. It would be discriminatory. I had the thought that crossed my mind was that news clip where that journalist is interviewing Pierre Elliott Trudeau and asking how far he'll go with the War Measures Act. And the journalist basically says, how far will you go with that? How far will you extend that? You can't do that. And Pierre Elliott Trudeau says, just watch me, which was one of his famous clips. So we'll see what he does.
Yeah, I mean, we spoke at quite some length with Michelle Rempel-Garner and with Brad Redekop. They spent quite a bit of time with us describing what their concerns were. And for them, certainly a key concern is about misuse of the immigration system integrity, and trying to figure out ways. And I think one of the big preoccupations is about, are people misusing the refugee system, making false claims, and really want to try and figure out ways to make sure that that misuse is being minimized, that, so that was, and also just, I mean, something that we heard from Ms. Rempel-Garner was like, has not the definition of who is a refugee expanded? I don't believe that it has. I mean, I think that, but anyways, this was something that we talked about it. So they were really eager, both of them, to try and get input from the Canadian Bar Association and from the other stakeholders that were there to figure out ways to like, put more control systems into the immigration system. And I think the feedback we had was that like there are lots of control systems, and that that if there's going to be targeted fraud control, that fraud control should be done in a targeted manner, not just by providing mass cancellation powers, which are just not democratic. And so, and I think that there was some uptake to that like, this is just making the whole legislation susceptible to charter litigation. And, and there's not that appetite for there to be this, because that creates liability for the government. But yeah, it was definitely a long, a long conversation about that. And same with Samir Zubari from the Liberal Party was like, again, actively trying to solicit this. But I think that they're very keen to move forward on an urgent basis. And so while they seem to understand that there are some weaknesses, there's like a real sense of urgency about putting something in place fast.
No, I have no doubt that, they'll have, as they say, we have no immediate plans to use it and no actual plans to use it until the minute the legislation's passed, and then they'll use it. Anyway, but moving more on to today's main topic, which are about refusals. One way, I guess, you can control issues within the system, and particularly, at least to start with, refusals and express entry. Express entry is Canada's largest immigration program. Some will say it's technically an application management system, and that the programs are Canadian Experience Class, Federal Skilled Worker Class, and the Federal Skilled Trades Class, to the extent that the latter is still active. In all of these, and I think the topic, the main thrust of the topic will be what I think is probably the main source of refusals in this area, and also the most preventable, are issues to do with employer reference letters.
Yeah.
Would you agree that that's probably the number one cause of refusals in express entry?
For sure. And I would say even more than that, like even more specifically, it's whether or not the job falls within the NOC that was
Exactly.
declared. Yeah.
Yeah. So within within all of all pretty much all of Canada's economic immigration programs, applicants have to show that their work is skilled. And not just that, but they also have to show that their work falls under a certain national occupation classification, also short form a NOC. I've often commented before that the NOC is like the hidden backbone of Canada's immigration system, because even though you wouldn't think it if you're not interacting daily with the system, Service Canada's national occupational system becomes relevant in every category of application. So what Canadian immigration legislation says across pretty much all programs is that in order for work or a job to meet the requirements of a NOC, it is necessary to perform the lead statement of a NOC. So for example, for chefs, which is NOC 62200, every occupation in Canada has this 5-digit number. That lead statement is chefs plan and direct food preparation and cooking activities and prepare and cook meals and specialty foods. They are employed in restaurants, hotels, hospitals, and other healthcare institutions, food commissionaries, clubs, etc. It is also necessary to perform a substantial number of the main duties of the NOC. So again, for every NOC, there is that lead statement that I just read, and then a list of duties that people in that occupation perform. There's too many for chefs to go through the whole list of, like I've just pulled it open, and there's 8 duties that head chefs perform, 9 or 10 duties that sous chefs perform, and then another 6 that specialist chefs perform. And so the big issue with express entry and these reference letters is that an officer needs to be able to read the list of duties that are in a reference letter and determine that they fall under the NOC. The 2 big issues that arise then, and which employers may miss, is number one, a lot of employer reference letters don't list duties. So that would be an automatic refusal, because then it's impossible for the officer to assess whether they perform that lead statement and a substantial number of the main duties. The second is whether the duties that are described in a reference letter fall under the NOC. And this can become a bit of a delicate balancing act, because you obviously don't want to just copy and paste the
Not
NOC
obviously,
duties.
but you don't.
Yeah. But at the same time, if the employer is writing a general reference letter and isn't hitting these duties, it could also lead to a refusal.
Exactly.
And
yeah, one might think that copying the job duties would be very intuitive, but actually the jurisprudence has shown that it is not an unreasonable assumption for an officer to make that suggests it's not a genuine job description.
Mm-hmm. And a further issue that arises and is unique to express entry is that in order to get points, it is also necessary to accurately declare what NOC someone's job is. So regulation, I believe it's regulation 15.4 of the express entry ministerial instruction says that in order for someone to be assigned points for their Canadian work experience, a foreign national must specify in their expression of interest the 5-digit code in the national occupation classification that corresponds to each occupation they have engaged in while accumulating Canadian work experience, that they have to have performed the actions in that lead statement for the NOC, as well as a substantial number of the main duties. And it just seems, at least in people contacting me, that this is becoming an increasingly big issue, showing that you accurately declared a knock. And you're increasingly seeing people who I don't think there's any doubt that their position is skilled and that they qualify under the program, but did they accurately declare their knock?
There's another thing to tease out here, which is that let's say you're talking about Canadian experience class. Like Canadian experience class, you can gain your experience in more than one skilled occupation. So let's say you spent part of your time working as a licensed practical nurse and part of your time as a registered nurse. That's all skilled work experience. And so if you have 1 year in a combination of LPN and RN, then you're good. As long as you meet that threshold for 1 year, good to go. But the application form on Express Entry only allows you to declare one primary occupation. And now the CRS, the Comprehensive Ranking System, which is the one that's defined in the ministerial instruction that Steve showed, says the CRS points need to be tied to that primary occupation that you've declared. So it starts raising these points as if they're in a combination of different NOCs, even though it's all skilled employment. Does that mixture of skilled work still attract the same number of points?
Right. And then, so sometimes to address this, everything with immigration just becomes more and more complicated, is that some employers, and I do think it's actually a good practice, if there's a list of like 8 duties, might specify the percentage of time that someone is in each duty in order to get to why they're declaring that as their knock. And this can especially be helpful. Sometimes you'll meet people who might be managers or supervisors, but it also says, for example, that they, let's say if it's at a restaurant, may serve food as required. And all of a sudden that may serve food as required could throw them into different knocks. And maybe they don't do that a lot of the time, but the person who wrote the reference letter was just listing everything that they do. That can and has caused refusals with an express entry.
Yeah. And I mean, I think that the reality of the labor market is that a lot of jobs have blended job duties. And, one of the best examples of this is in the IT field. These occupations are divided out and they are notoriously difficult to distinguish. I will give, you take a room full of immigration lawyers and you ask them to characterize the knock for a software engineer, a web developer, a web designer, a regular software developer. I think that you are guaranteed to get 2 or 3 different knock codes for each job description, even people that do this all the time. And so there is a lot of replication. And so it's not always an easy task. And so, I mean, we talked about this a little bit last episode, but, it becomes very challenging to figure out what is the correct one to choose, especially when duties might be added, duties might be taken away. You add a supervising thing, and that means you lose some of this and that. And so, so it just makes the job of creating an accurate job description more challenging.
No, and where it's also becoming an increasing issue, and this is a relatively recent thing. You used to not see issues based on, say, distinguishing types of software. But for example, the computer knocks, for example, trying to figure out which one you are, and if you're in software development, try to figure out, are you able to look at your job and determine, here are a bunch of different software knocks. There's software developers and programmers, computer network and web technicians, computer systems developers and programmers, database analysis and data administrators, information system specialist, information system testing technician, web designer, web developer, and programmer. And again, historically, I don't think officers really looked at the distinction between all of these. They used to just be like, oh, it's all tech. and trying to decide between information systems specialist and information systems testing technician is a bit of a fool's errand because, who really cares? They all qualify. But I've just seen people coming with refusals in the traditionally, what I called them, the complicated tech NOCs, that normally officers wouldn't go and do this fine tooth trying to distinguish between one and the other. And now it seems that they are.
Yeah,
Of course,
I mean,
I've
they
talked
used to
before
see
about
some of those in terms of specialized knowledge because some of them were at a lower knock level, like between a tester and a designer, but not so much in terms of um, like a designer, a computer designer or developer, and a web designer and developer. It's just what's your platform as opposed to what's the actual, and that really does come down to like what software and what's your platform. So it is really complex, and I don't think a lot of people think to drill down to that level
right?
of detail.
I mean, I talk, I've years ago, so I guess it isn't that recent that this became an issue. We did an express entry application for someone who was previously refused and who even had a JR dismissed at leave, where they were refused because they declared that their knock was senior manager construction. And the officer actually wrote that it was more likely senior manager, not elsewhere classified.
Yeah,
And
you said
that distinction led to a refusal. The other one on just this substantial number of main duties, and where people really need to take the reference letter that they receive and run it against the knock, is, for example, when it comes to this issue of a substantial number of main duties, I think most teachers who say that they teach a course would assume that it's obvious that included in that is assign and correct homework or prepare and administer correct tests. So for example, just because I'm giving this example, the main duties of a teacher are: 1, prepare subject material for presentation to students; 2, teach students using a systemic plan of lectures; 3, assign and correct homework; 4, prepare, administer, and correct tests; 5, evaluate progress; 6, prepare and implement remedial programs; 7, prepare and staff meetings. And then there's 3 things that they may do. I think most schools that prepare a reference letter would think that it's obvious that if they say that they taught a school, or taught at a school, that includes assigning and correcting homework or in preparing and administering tests. But those are specific duties listed in the knock. And if it's not declared as a specific duty in a reference letter, you may have an officer arguably reasonably saying that they did not show that they did a substantial number of the main duties.
I want to point out, because there's a question from Hash that just came in, a listener who says, is this an extra legal standard in CEC? So I want to address this now because I think that it's the right time to be raising it. I don't think this is an extra legal standard. I think that what the point is here is it's always a requirement for every applicant to understand that they need to meet the requirements in the class in which they were invited, but also to make sure that they've justified the number of points that were given to them under the CRS ranking system. That exists for everything. And while I think people have sort of played a little bit looser with this in the past, right now it's absolutely essential to make sure that you've justified absolutely every single point that you've been attributed, because everyone needs every single point that they've been given. So it's not enough to just say, look, I have this 1 year of skilled work experience. It's now necessary to say, to show and to be very, very sensitive to the fact that you need to make sure you've justified your compliance with that NOC code, but that also that you're looking at whether or not your points for the purposes of your CRS points, there's one that, the number of years of work experience that you're getting credit for in the ranking system, if it's like 2 years or 3 years, that they match the NOC code that you're putting in there as your primary occupation. And so also just be really mindful of that.
Yeah. And
Yeah.
I think Deanna hits it right on the head. Like, the reason we're raising this is because we see refusals that are based on I think it's the main issue with reference letters. I guess we should add that all reference letters also have to say how many hours someone worked, because you have to show that it's full
Full
time. It's not
time.
enough to just say full time, because that can vary
Yeah.
country to country. It has to have the name, obviously. Has to state what the wage is, because the work has to be paid. And the other issue that arises in reference letters is if someone gets promoted, but they just have a list of duties for, say, their most recent position or something that one list of duties to capture all their jobs, it again becomes unclear to the officer what was being done in each role.
Yeah.
And it really is necessary to go over the reference letters with like a fine tooth comb. Also, double checking if a verb, whether there's assumptions being made about verbs. So words like support, assist, help. I've reviewed one reference letter where a lot seemed to hinge on maintain the flow of the establishment. And that might have been clear to the person who wrote the reference letter, what that meant. But both to the officer and then to me reading it, although we were ultimately successful on judicial review, it's not clear what that actually means. And I guess the best practice would be like not to copy paste from the NOC, but to look at the NOC list of duties and that lead statement and be like, we know what our objective is. How can we accurately list our duties to get us to the objective of
Yeah.
showing that we performed a substantial number of them?
Really, officers not only don't need to, but will not reach out for further clarification. And so you need to go above and beyond the call of duty when it comes to rationalizing and justifying that this actually does meet the description that is set out in the NOC.
That's
Not
a
by
good point.
copying and pasting it, but by actually providing the rationale from the employer, not from the applicant, but from the employer to say, this is why we are making the argument that this fully complies with this job description.
That's a good point. Do you want to elaborate on that procedural fairness issue? Because I think a lot of people will say, well, the officer had a duty to contact me to seek clarification.
Yeah. So in terms of procedural fairness, it's very much that if the concern of the officer is whether or not enough information was provided by the applicant, there's really no duty on that officer to reach out and say, hey, we don't have sufficient evidence to support this application. The court will find if it's about sufficiency of evidence, there's no breach of procedural fairness. If, on the other hand, they're looking at a document that they don't understand, or they're going to take issue with whether or not they believe it's fraudulent or not fraudulent, those are the types of situations in which they need to go back to you and seek clarification. But otherwise, the onus is firmly in the applicant's hands to put enough information in front of the officer to make the decision positive. So do not expect them to come back to you at all. It's on you. And I think that they're really taking that road every chance they can get. This is how they're managing their numbers. Don't leave any doors open for them to just be like, no, I'm not satisfied. And that's really that's what all the decisions say. They don't say, I refuse because I don't believe you have done this. They just say, I am not satisfied that you have done this work. And that's the kiss of death. So really do go that extra mile. I used to think I was paranoid because I put in a full set of pay slips for the entire period of time that the person was working in the job, just because most often, and I look at them very, very carefully to make sure that they all show minimum 30 hours per week for that pay period, and that they show the job title. If they don't, I would ask for clarification. I would have the employer address that. But now I don't think it's overkill. I think that that's bare minimum. But notice that if they will add up, at least they do this in the caregiver field regularly. If they don't already do it in the express entry field, they will start. If the pay slips don't match the T4, if the T4 doesn't match the notice of assessment, they will come back. They could either just say there's something wrong, and maybe eventually they'll just start refusing. But with the caregivers, at least they're coming back and saying, can you please clarify why there's a mismatch here?
Yeah, I historically for Canadian work always went with the minimal approach of just a reference letter. I don't think there's a right or a wrong way to do it, but what I would say though is kind of as Deanna is alluding, if you are going to provide pay stubs, and there's a week where for whatever reason you work 20 hours per week, just note that in the CEC, when they say that they want 1 year of full-time work experience, they mean 52 weeks of full-time work. And if you have 1 week that's less, arguably you'll need to make up for it with an additional week.
Yeah, including like, you know, and when people have put in their travel history that they were out of the country for 2 months, I've seen cases where they've said, well, those weeks, even though you were out of the country for work, you weren't physically in Canada, and those don't count towards your 52 weeks spent in Canada doing your job. So,
Yeah.
so again, these are the types of things to be uber paranoid about.
Okay, we have some good questions coming in. Deanna and I both have hard cap on when we have to be out of here. So let's, back to Bill C-12 with Rupesh asking, hi, Stephen and Deanna, good morning. Will CC have a draw size of more than 1,000 ITAs in 2025, or are they done for the year? I'm at 522 and will lose points. Sorry, this isn't a Bill C-12 question. This is a express entry ITA question. I do not know if they will have a draw size of more than 1,000 ITAs in 2025. I do think that points will come down a bit next year. I've become more optimistic than that on that. I think the TR to PR pathway, because they say that it is for skilled work, means that it should be people who are also in the express entry pool already. And that, in theory, should open a ton of new spots for CEC applicants. If you have any thoughts on that, or we can...
I feel like I'm bad at predicting generally. Yeah, my jury's still out. I mean, I am
we'll see. I haven't announced the details of what this 33,000 extra spot is, but if it is
but it's
limited
for next
to skilled,
year, yeah. I mean,
it's for next year, and if it is limited to skilled people, you can almost view that as 33,000 more express entry spots in a way. Which,
yeah,
which
I'm not convinced that it won't be through express entry, but like,
yeah,
but we never know. Yeah.
Nash asks, if Bill C-12 passes, would IRCC cancel applications under the SUV program and the ones associated with non-priority designated organizations? Is there a timeline for that to happen? And then if it is not canceled, what is the remedy for the situation where only 500 spots are allocated for the year in 2026?
Nash, I would say that when I saw the numbers that they have allocated for startup visa, I immediately thought that this was one of the target areas, particularly because of what she said about mass fraud. I think that the way that they de-designated certain designated organizations made me feel like that would potentially be an area where they might say that they are concerned about the integrity of the startup visa program. That is definitely what they did with the entrepreneur and investor programs in the past. You know, I don't even want to know how many applications are in the backlog in that program. And so
I think it's something like a 30-year wait right now for new applicants.
Yeah. So I don't wish to be a doomsayer, but none of what you've suggested would surprise me, because you know, it does feel like a bit of an ill-fated program. You know, Canada's history with investor entrepreneur programs. You know, they had said at the outset that this was supposed to be an incredibly niche program, and then it grew exponentially. And I think that there's been a ton of litigation around it. Like, I think that they're
very low approval rate.
Very low approval rate. They've kind of made it impossible for people to do anything because so many of those business ideas have kind of been choked out by the fact that they've not approved for such an insanely long period of time. So I really don't know what to say, but I can understand why you're feeling very worried.
Yeah.
How
In
long would it
theory,
take?
it could be possible to do if they do cancel, if they have the ability for nuance to distinguish between people who are here and people who aren't. When they canceled the federal investor program and the federal skilled worker class in 2014 and 2012, respectively, they didn't have that level of nuance. Maybe they will this time. A lot of
Yeah,
uncertainty.
for sure. And I think that there will be litigation around this if they try to mass cancel this category. Again, it's about how they did it. They did that with the federal skilled worker backlog, and they weren't like the litigation was not successful. But I think that this could if they use the new cancellation powers, I'm imagining that that would end up being like very involved. If they do it through order in council, I think that there's a lot of questions about whether or not you can challenge it legally because it's done by order in council. So I think a lot of people are thinking about this in terms of timeline. I really don't know, but I think it could be fast.
Yeah. AG writes on X, basically IRCC is working on finding any issue instead of working with positive approach to approve applications. It's well-known reality that actual NOC code duties could be different than real job duties, even though if you mention the exact same duties, they deny it. They even do not recognize that big corporations don't provide format as required by IRCC. Just on that last point, that is a common issue where a lot of HR departments will provide standardized reference letters. Doesn't change the fact that the applicant has that onus of showing that they did the lead statement a substantial number of duties. IRCC is pretty good in those situations of accepting other proof. So it could be a letter from your manager, a letter from coworkers that does list your duties, and then a statement from you that HR just doesn't provide a reference letter that lists duties. That's a common issue and one that can be addressed. The rest of what you say, it's sort of the IRCC expects the reference letters to conform to what the legislation requires.
Yeah, but I totally agree that like the idea of IRCC treating applicants as if they're their clients and that they're trying to work in a collaborative way, I couldn't agree more.
How all the refusals end with "Thank you for your interest in Canada."
Yeah. Yeah, I commented in my LinkedIn about an article written by Nicholas Kyung, which I thought was just great because it really talks about like the lack of this kind of constructive approach. I just think he hit it right on the head.
Yeah. Drewski asks, I recently got an invitation to apply. In my reference letter, my employer didn't state that I was full-time, but mentioned that I work 40 hours a week, mentioned the salary and years work. Will I get denied? So it's not necessary that the employer use the words 40 hours per week. Or no, sorry,
Or
it's
not
not
the word
necessary
full-time.
that the employer use the words they work full-time. If an employer letter states how many hours it was per week, and it is more than 30, which is full-time in immigration land, then that's sufficient. The employer doesn't have to say explicitly it is full-time. Stating the number of hours is totally fine. Well, what are your thoughts? Are they going to cancel people's permanent residence? Sabir Ahmed, sorry, I messed that up. Sabir Ahmed asks,
You got there.
if C12 passes, is there a chance they might cancel PR as well?
So C12, the power that is conferred on the minister gives them the power to cancel PRs, but I can't really imagine a situation where that would become likely to occur. I'm fearful of why they gave themselves that power, but again, I think that the likelihood that they would use it, I think it's more remote, put it that way.
Yeah.
Because I think that the likelihood of major backlash would be higher.
Yeah. Nash asks whether there could be a TRPR for 2026 to 2027 that could include those applicants under the SUV program on a work permit. Maybe. We don't have any details. Yeah, that's could.
Yeah.
It could.
It could.
I don't know what this comment is pertaining to exactly, but if you saw me smiling earlier on YouTube, it's because I was reading about it. FATE, FAI 8T, FATE, 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 TT. Anyway, Says, I talked 5 years ago about client instead of applicant. If that was the case, it's been a, sorry for the language, shitty service for 7 years, and I demand a full refund. Not sure what that pertains to, but it does, it is interesting how IRCC views the people that it's banning from Canada, for example, as clients. I've always thought it was funny language, but that is the way that they view it. Unless we get any further questions, the last one, Jay on Twitter says, is the foreign experience locked after the ITA, the invitation to apply, or the EAPR, the electronic application for permanent residence? My foreign work experience will decrease in 3 weeks. The requirement for express entry is that you have to have the points both at the time that the invitation to apply is issued, as well as at the time that you submit the electronic application for permanent residence. There's a special rule for people whose birthday occurs in between. But beyond that, it's both ITA and EAPR. And we do have a last question from Huntessers
The
9195.
answer to that, though, is I think if you've already applied for permanent residence, I think you're good.
Yeah, if you've already
Right?
applied for
Yeah.
PR, you're good.
Yeah.
Changes that occur after don't impact things. There used to be an issue with arranged employment and express entry for the federal skilled worker class specifically, pertaining to the 69 points out of 100 or the 67 points out of 100.
Yeah.
We do have a last question, and I'm look it up quick, but I have a score of 449 with French. What are my odds of getting an ITA before 2025 ends? I don't know if there'll be another French ITA. If I had to bet on who will get an ITA, it would be Francophones, just because they get the most frequent.
And their last
STEM,
draw
there's
was
still not been
416.
a STEM draw, and the last draw was 416. So if they do another ITA, I think the odds are high. And then, of course, next year, they're going to continue the Francophone targets. So if not this year, then likely next year. And with that, that was a lot of questions.
Well, we've got 500 people watching, so.
Yeah. Well, thanks. Oh, we've got Instagram. So we'll do the Instagram questions quick. Henry says, what happens when an employer refuses to include job duties? We already mentioned that. You can get it from other sources. And then Ravinder Kaur asks, is there any hope for the education category based draw? Because this year it was only 2 draws and the total number was only 3,500, a very low number in education category draw. Deanna and I don't have, unique insight into draws. I think STEM would be more likely than another education draw, simply because they haven't done a STEM draw yet. And what's the point of the category if they don't do anything with it? And I don't think the categories have been announced for next year yet, with the talk of military, researchers, and senior managers being added.
Yeah.
And Fatey replies, I was just referring to the notion that immigrants are viewed as clients for a company called Canada instead of actual humans with lives and stories. That's interesting. That's a neat perspective.
No,
I will leave a
think it's
Google
really
review.
true. Yeah, I think it's absolutely true. I think that this is something that we've talked about repeatedly about what is happening to the Canadian brand. And I think that Canada has been a little bit nonchalant about what this is doing to our reputation internationally. And I've been talking to a lot of people who are saying that even though they've immigrated even successfully, that they've decided that they're ready to leave because they no longer feel like the things that they came for are present. So, and again, I say this is, if you follow me on LinkedIn, this is something that article by Nick Kyung, who's from the Toronto Star, was really talking about. I think that we are being quite arrogant in assuming that being a desirable destination country is going to follow us perpetually.
Yeah, Martin Bashir talked about that in his Build Canada episode that we were on.
Yeah.
That he was on.
Yeah, I think that Canada really needs to have a wake-up call, and I think that there are other jurisdictions that are happily and Nicholas was talking very much about how, all sorts of countries that have not been open to attracting and retaining talent, like the United Arab Emirates, are suddenly saying, oh, okay, you don't want that talent? Well, we'll take it. And so, I think that we're seeing the world kind of flipped on its side. And, Steve keeps making jokes about how I'm going to move to Japan, but like during the very short time that I spent there, you're kind of seeing that they, like other jurisdictions, just seem to be where we were at a decade ago, where it was like, we want to attract the best and brightest. We are going to move in a different direction. We are saying now, closing the borders,
although I think Japan just elected a super conservative prime minister.
Never know.
But anyway, so, Fate 8, I can't pronounce that, but is going to leave a Google review for the company called Canada. Please leave reviews if you listen to our show and watch our show, which if you're hearing this, you do. So like and subscribe wherever you listen. And
especially on YouTube, because we're almost at our milestone that maybe will help us actually break even at this enterprise.
Yeah.